Is the audio fine now? Thank you, Parmeshwari, for the comment. Okay, you aren't audible. I have changed the audio setup. Now, quickly point out if the audio is fine. Thank you, Aditya. Thank you, Sharvarit. Thank you, Bipasa. Okay, chale, guys. So, this means we are good to go. Okay. Some people are discussing whether to join Jindal or not because the first round of admission have just begun for Jindal Global Law School. Well, guys, from personal experience, in last 10 years, I have not seen even a single student regretting when after joining Jindal. So even after 5 years, if we ask, was it a good decision? Maza aaya college mein, they will always say yes. The only people who will regret would be your parents while paying that hefty tuition fee every year. Having said that, so let's start today's session. This is not the forum to discuss which college to join. So we'll talk about legal news item. Well, the first news item that I want to discuss is related to women's right. Let me just see if the presentation is also changing on your screen. Yes, it is. Great, guys. Okay, so if you guys haven't started preparing for CLAT and if you want to try out IMS Get Set Law product, you can log on to our channel. You can go to our website and register for a zero free program. Just take a view, just find out how the course look, how many 8 hours worth of content will be available free of cost for all of you. Well, moving on. Is marital rape legal in our country? How many of you know about this issue? Rape is a punishable offence under section 375 of the Indian Penal Code. If you look at section 375, it says rape is a punishable offence under two circumstances. First, when sexual intercourse is done by with a woman by a man. IPC was drafted in the year 1860. 150 साल पुराना कानून है by Lord Macaulay, chairman of the first law commission. Therefore, this historical piece of legislation, this historical rule book has certain provisions which we will not consider suitable for the modern understanding. Yes. So, for example, if you just look at first condition, rape is an offence only when it is done to a woman by a man. So, what if a man got raped? Well, that will not be covered under section 375 of IPC. So that is the first lacuna. Anyways, so first condition is that rape must be committed against women by a man. Second condition says that such sexual intercourse must fall under any of these 7 circumstances. Let's quickly go through the list. It should be against her will or without her consent, or it should be with consent but obtained under fear of death or hurt. Consent if given under a misconception of the fact that the man is her husband, or consent is given because of unsoundness of mind, intoxication, or under influence of any drug or wholesome substance. With a woman, or if it is with a woman who is under 18 years of age, with or without her consent. If victim is under 18, even her consent will not matter. And last ground is when a woman is unable to communicate her consent. So, victim should always be a woman, and second thing, it should happen under these circumstances. Not just that, there are a few exceptions to these rules too. Isn't it interesting? So, there are 3 major exceptions which you will find to the offence of rape. First one being if the woman does not physically resist. So, you can say this is defense of consent. Second thing is when sexual intercourse or sexual act is by a man with his wife. So, if a person rapes his wife, it will not fall under section 375 unless the wife is under 15 years of age. Third exception is a medical procedure. So, if penetration is because of some medical reason, then that will not be counted as rape. Okay, so let me just quickly go through some of the comments. What are people saying here? Vipasa says, I can't hear you. Is that so, Vipasa? Is the audio clear now? Okay. Tanishka Jagtap, not illegal between husband and wife above 18. Yes, recently this age limit was changed. So if wife is above 18 years of age, then it is not considered rape. So does it make any better कि अब तो एज बढ़ा दिया 15 years, नहीं अब 18 years का exception है? Well, it won't change anything, guys. Well, this means that we have legally allowed people to commit rape with impunity. That means no punishment. Okay. Chaliye. So in this case, it has been argued by the petitioner that the offense of rape, marital rape, because of these exceptions is not getting recognized and people are not getting punished. Marital rape is violation of a woman's right to give consent. So a right to choice. Right to choice also includes in various, can be manifested in various forms, and right to choice also means right to give consent for a physical relationship. So it is violative of Article 19(1)(a) of the Constitution. What is Article 19(1)(a), if anyone remembers? Article 19(1)(a) talks about, let's see if somebody can guess that in the comment section. Moving on. So it was also argued that exception 2 of the section 375 IPC does not recognize the right of a woman to say no to sexual activity with her husband, and therefore it also violates women's other fundamental rights. So other than Article 19, which other fundamental right is getting violated? Welcome Harsha, welcome Vipasa, welcome Arya. Okay. Rishikesh, very good evening to you too. ये बताइए, which other fundamental right do you think gets violated? One is obviously Article 19, freedom of speech and expression, which includes freedom to give consent. Okay. Yes, Dikshita, your answer is correct for the previous question, but what about this one? Which other right is getting affected? It says other fundamental rights and not just fundamental right. Well, it was also argued that this exception is unconstitutional as it places privacy of marriage above privacy of an individual. Why do you think our forefathers or lawmakers, when they were enacting this law, kept this exception? Why did they find it necessary that marital rape should be given an exception? Yes, Ananya, your answer is right for the previous question. It is violative of Article 19 as well as right to equality, Article 14. Article 15, okay, chaliye. Right to privacy, that means Article 21. Anyways, so multiple fundamental rights are getting violated here. Our forefathers or the lawmakers initially, when they were debating these provisions, it was argued that marital rape should be included. Okay, Satesh has a point to make. Due to patriarchal society in those times where women were considered secondary. Okay, so अब तो उस चीज को इतना टाइम हो गया, why are we not removing it now? Why this exception still exists? In India, when we are enacting laws, we try to tilt it slightly in the favor of the weaker section. So many times these laws are also misused. We talked about Juvenile Justice Act in a previous episode. So earlier, as per law, juveniles were only punished for a maximum jail term of 3 years for any offense that they commit. After the infamous Nirbhaya rape case, a few changes were made in the legal system and we reduced that bar from 18 to 16. Now, if you're a minor, if you're under 16 years of age, then whatever you commit, court cannot give you a longer jail term than 3 years. But if you're above 16 and under 18, then for offenses such as rape, murder and other heinous offenses, they will treat you as an adult and they will give you more stringent punishments. Okay. Yes, guys, most of you are right. Because of the male dominance, because of the patriarchy, it played a very crucial role here. It used to be believed that after getting married, it becomes a husband's unquestionable right to have physical intercourse with his wife. Law also recognizes something called conjugal rights. Conjugal rights are those rights which you acquire because you got married. So rights related to marriage, which includes right of cohabitation, that means right to stay with your partner. Do you know, even in Hindu Marriage Act, if your spouse is not staying with you, let's say wife बुरा मान के मायके चली गई है या हस्बैंड बुरा मान के कहीं और चला गया है, you can approach the court and claim your right to restitution of conjugal rights. That means मुझे मेरी वाइफ वापस चाहिए या मुझे मेरा हस्बैंड वापस चाहिए. So you can go to the court and ask court to get your spouse back. Why? Because the right of cohabitation comes along with your right to comes along with your married life rights. So right to cohabitation as well as right to have a physical relationship. So these grounds can also be used in divorce cases. Let's say agar my wife got angry and she goes to her parents' place and I go to the court claiming restitution of conjugal rights. What will court do here? Will court send some cops to her place to abduct her and bring her back? No. They will simply pass an order stating that this is what court wants, you should go back. If that person still disagrees, that person will not come back to you, and then you can use that as a ground for divorce. Anyway, so coming back, I was trying to make a point here that many times we create laws in order to protect the weaker section, and at times these rules are then misused by some people, and as far as laws related to sexual harassment or rape are concerned, we have diluted the standard of proof which earlier we used to require in such cases to a new law now. Even if we don't have enough evidence, judges have been convicting people in rape and sexual harassment cases. So there are many laws which protect women. Can you cite a few? Any legislation or statute which you are aware of? Have you heard of POSH Act? POSH Act, Prevention of Sexual Harassment at Workplace. What about POXO? Anyone can come up with full form of POXO? नहीं पता. Anyways, चलिए आगे बढ़ते हैं. So it was argued that this exception is unconstitutional because it is putting the right of conjugal rights over a person's individual rights. So conjugal rights are more important than individual right. This was the understanding. Government was trying to protect the institution of marriage. So institution of marriage or the piousness of institution of marriage. No, not right to property related nahi hai yahan pe. Acha, this is the answer to my previous question. What other laws are there to protect women? Yes, we have made changes to property laws. We have created statutes such as Domestic Violence Act, Protection of Children Against Sexual Offences. Yes, Ananya, that's also an example. Okay. Dowry prohibition law is also there. Cruelty is also a very much misused provision. Section 498A and Section 498B. Section 498A is considered India's most misused provision. We'll discuss that provision at length some other day. Today's agenda is exception 2 of Section 375. Well, it was also claimed that marital rape exception, which gives institution of marriage, which is trying to protect institution of marriage and the connected conjugal rights, cannot triumph over wife's right to privacy and other things. So what is more important, that people shall stay married or right to equality? Just put it that way. What is more important? Let me try to offend some of you or try to put you in an awkward situation. What would you people like? Your parents to stay together or your parents to stay happy? Now put it on yourself. How would you think? you would prefer to stay? Happy or together? Both can also be an answer. But what if it is not there? What if you have to pick something? So in any case, obviously people will go for happy. They should. But when you're living in a patriarchal society, women are generally taught to bear pain or to suffer and to stay mum, to stay silent. And that's the reason, even if we try to liberate them, even if we try to give them more freedom, majority will still stick with the old norms. Chale, so that is the reason that this provision didn't get popular support in our country. इसलिए exception आज भी है. And wherever there is popular opinion, government will always tilt in the favor of the majority. Chale, let's move on. So in this case, because the petitioner was asking the judge to remove this exception from the statute book. Now judge got confused and puts up a question that if I remove this provision, if I remove this exception, will I be creating a new offense? So you can simply answer yes or no. क्या लगता है आपको? If the judge removes one exception from section 375, does that mean a new offense got created? IPC में एक provision और add हो गया? No, new offense is not getting added, but a new category of offenders will get added. So some people which earlier used to get scot-free, which used to go scot-free, now those people will also get punished. So it was argued that no, it is not creation of new offense, but only creation of new class of offenders. Chaliye. Well, because of this exception, many people have been violating, many people have been suffering, and as earlier some of you pointed out, it is also violating people's right to equality. So Article 14, Article 21, Article 19, three of your major fundamental rights are getting violated because of this exception. So इसमें कोर्ट ने गवर्नमेंट से पूछा आपकी क्या राय है, क्या लगता है आपको? What will government say? So a question was put up to the central government, Home Ministry. So we are thinking about removing exception 2 from section 375 of Indian Penal Code. Okay, Ovais Khan has a question. What about innocent till guilty in rape cases? Then if lack of evidence convicts the accused. Okay, I'm not saying that you will be held accountable or you will be held guilty even without any evidence. What I'm trying to say is that the standard of proof which is generally required is not that high, right? There are reasons for that. In Indian society, rape is also a taboo. If someone gets raped, you're not just violating that person physically, you're also violating that person's, harming that person psychologically, emotionally, as well as physically. The society will not accept the victim. There's a lot of victim blaming going on. So in a situation like this, many rape victims don't even come out or they don't even complain about that offense. So let's say after 3 years, that lady victim was able to muster some courage and decided to lodge an FIR. So do you think there will be enough physical evidence available after 3 years? Not at all, right? And you're talking about something which happened 3 years back. Let me give an example to so that you people can relate. Have you heard about that famous case against Asharam Bapu? Asharam Bapu, Sant Asharam Bapu wala matter pata hai aapko? Sexual harassment controversy. Okay. So if I remember correctly, the victim was from UP. Victim was from UP. She went to, as per her story, she went to Jodhpur, Rajasthan. I am in Jodhpur right now, by the way. She went to Jodhpur to attend a satsang of Asharam Bapu. Asharam Bapu was a godman saint from Gujarat. So he used to visit multiple cities for delivering sermons. So this lady from UP came to Rajasthan to attend sermon of a godman from Gujarat. Then after a year, she goes to Delhi along with her father to lodge a complaint. So एक तो complaint इतना late file हुआ. Now look at multiple jurisdictions involved, right? Victim is from Uttar Pradesh, accused was from Gujarat, crime took place in Rajasthan, and FIR is being lodged in Delhi, and that too after a year. So should we think, if this something like this happens, so shall we presume that this victim is lying? No such incident took place just because she is filing complaint or she came up after 1 year. No, we can't. So in order to protect such victim, court started accepting late complaints, court started accepting weaker evidences. Aryan says jurisdiction will be where the crime occurred. That's correct. And therefore, Asharam Bapu is in Jodhpur Central Jail and not Delhi Tihar Jail. Okay. Check it. So, all being said, let me summarize it here. IPC prescribes defines various offences and prescribes punishment for those. It was drafted like 150 years back, and therefore all the facts and circumstances of societal situation back then were considered while drafting. Even today, if you look at majority of India is rural, and therefore there will be very less acceptance of any such new offense, right? Government is also scared that once we allow marital rape to be recognized as rape or equivalent to rape under section 375, then in almost every other divorce petition, one additional complaint will be filed that I was also, the husband was asking dowry, they were mentally and physically harassing me, along with that I was also raped couple of times back then. So you are increasing troubles for future husbands. Anyways, आगे बढ़ते हैं. So keeping this in mind, government is also hesitating. Government is also not sure उनको ये करना चाहिए कि नहीं. I can't see my cursor, so I will have to. चलिए आगे बढ़ते हैं. So how did the central government react? Government ने क्या बोला? Government ने बोला please take a break. अभी हमें time चाहिए. So government Home Ministry filed an affidavit to the court, and they said that we want to do more research on this thing. We need to consult all the stakeholders. So it would be better if the Delhi High Court defers the hearing of this marital rape issue for some stipulated time period. And after that, we will conduct detailed survey, we will do effective consultation and come up with a better answer, and then only we will submit our response whether this exception shall be removed or kept. Chaliye. Let's move on to another issue which you are seeing on your TV screens every now and then. Is wearing hijab a fundamental right? So let's start with this basic question. Is wearing hijab a fundamental right? Is wearing janeu a fundamental right? Should be? Okay. Yes, पता नहीं. Okay, yes, it is. So is wearing a turban a fundamental right? Yes, it is. So why not? Then why this controversy? If wearing hijab is already a fundamental right, as all of you are pointing out, then why this controversy? Vaishnavi says, no, it is not a fundamental right. Okay, is putting on a blazer a fundamental right? Can I put on coat? Yes, I can. Which fundamental right are you referring to? Liberty. Article 21, right to life and liberty. Which means I can live my life the way I want, isn't it? Okay, chaliye. So why this controversy? A writ petition has been filed by few students from a junior college in Karnataka. For those of you who don't know what junior colleges are, that means these are school kids. So if you're from Maharashtra, if you're from Mumbai, you would know junior colleges. If you're from Delhi, तो आपको लग रहा होगा कि ये तो college के बच्चे हैं. Well, junior college or pre-university college basically means senior schools, right? Okay, senior secondary schools. Anyways, so a writ petition has been filed in Karnataka High Court by a Muslim girl student seeking declaration that wearing a hijab, headscarf, is a fundamental right guaranteed under Article 14 and 25. Yes, it is a fundamental right, but under Article 21. But whether it is a fundamental right under Article 14 and 25, abhi wo court batayega. Okay, so another point which you should note down is that petitioner is saying that it is an essential practice of her faith, right? Okay, chaliye aage badhte hain. So there's this government run pre-university in Karnataka's Udupi district, and couple of students were not allowed to enter college one day. The date is December 28, 2021. So what started as you can say rift between two student group, was blown out of proportion and it became the national issue. So because few Muslim girls were wearing burqa, few Hindu guys started putting on a scarf, a muffler, gamcha, right? And then that thing picked up. So even those girls who were not wearing burqa earlier, now they started wearing burqa. And many other kids also starting putting on that scarf. Well, so the university had to interfere at some point of time. They had to intervene. ये क्या चल रहा है? So दो group बन चुके हैं, a lot of division, right? So university decided that we will stop all groups from showcasing their symbols, and therefore they denied entry to any kid that day who was wearing a burqa or a bhagwa, gamcha, whatever it was. Anyways, so matter इससे आगे बढ़ता है. College took a stand that petitioners and other similarly placed students have violated the dress code of the college by wearing a hijab. Now my question here is, shouldn't it be our fundamental right to decide what we put on? Yes or no, guys? So what you are going to put on, shouldn't you be the person to decide all that? So whether I put on a sari or a burqa, whether I put on a suit or a kurta, whether I put on, let's say, dhoti, or if I just put on couple of, a few more extra pounds, everything should be left to me to decide. चलिए इतना तो कॉमन सेंस है, एवरीबडी अग्रीज, ग्रेट. सो आप क्या पहन के जाएंगे ये आप खुद डिसाइड कर सकते हैं, अच्छी बात है. बट लेट मी गिव यू अ काउंटर व्यू. डोंट यू थिंक that uniforms are also required at some places in order to bring in discipline? When you went to school, were you guys asked to put on uniforms? Yes. Tomorrow if you join armed forces, will you be wearing a uniform? Yes. If you join police department, will you wear uniform? Yes. Right? Yeah, let me simplify. और भी आसान कर देता हूँ मैं. Whether people shall be allowed to wear whatever they feel like, or shall they put on uniform in school, will now be decided in the court of law. और अगर आप कोर्ट रूम का सेटअप देखेंगे तो डिसाइड करने वाला जज एंड आर्ग्यू करने वाले लॉयर्स भी अपनी अपनी यूनिफॉर्म में होते हैं. सो पीपल हु आर गोइंग टू आर्ग्यू वेदर इन फेवर और अगेंस्ट विल ऑल्सो बी अटेंडिंग दैट कोर्ट इन देयर यूनिफॉर्म, देयर ड्रेस कोड. Okay, chaliye. Yes, no, I am getting too much into comments right now. Maintain uniformity. Yes, schools are also required to put uniform code for discipline. Every institution has a dress code or uniform. Correct. So let's say अगर पुलिस हमारी तरह बोलने लगे कि we are not going to put up uniform, तो हमारी लोकल पुलिस आपकी फिल्मी पुलिस जैसी दिखने लगेगी. So every inspector will look like Chulbul Pandey or Singham, occasionally putting on uniform whenever they want to enter into a fight scene. Yes, it is a political drama which has gone out of proportion, and there is little to no sense in the entire controversy. So is there a ban on burqa in our country? No, there is none. Is there a ban on putting on Janeu? No, there is none. So but there are a few places where they have imposed uniforms. आप सब लोग स्कूल गए हैं, सबको पता है यूनिफॉर्म क्या होता है. So all of you have been there, done that. ऐसा कुछ नहीं है. So for example, if we today want to change the status quo, हम चाहते हैं कि नहीं हमको स्कूल में अपने रिलीजियस क्लोथिंग में जाने का राइट मिलना चाहिए. Okay. So in India there are people belonging to Digambar Jain community. They will say according to that we can also come naked to the college, isn't it? Then let's say some Kshatriyas will say we will carry kripan or talwar with us. Everybody will come up with some or the other thing. So it is one thing to exercise your freedom of religion. Another thing is that none of your right is absolute in nature. All your fundamental rights are subject to reasonable restriction. Well, so if you read Article 25, it says subject to, it is freedom of conscience and free profession, practice and propagation of religion. It says subject to public order, morality and health. These are 3 grounds, right? By the way, there are 4 grounds. Which is the 4th ground? Text of the article is on your screen. I hope you guys can read it. What is the 4th ground? So there is public order, morality and health. Public order, morality and health. And it says other provisions of this part. Which part? Part 3. That means it is also subject to other fundamental rights. For example, let's say in my religion, in my community, there was a custom of giving human sacrifice to the goddess on the 8th of Navratri. So अष्टमी पे बलि चढ़ाने का रिवाज है. Nice? कर सकते हैं? Can I say I have a right to sacrifice? What's more important, my right to practice my custom or the victim's right to life? ज़्यादा ज़रूरी क्या है? Right to life or my demand to practice or follow my religion? Answer is quite simple. Whenever something like this happens, right to life will precede or will be considered more important. There was a custom called sati. If I say it is my custom to burn widows after husband's death, वैसे भी husband मर गया, अब जी के वैसे क्या करेंगे, अच्छा जला दो. So if I say this is my custom, I want to do it. On the other end, there are people saying no, victim's right to life is more important than your right to follow a particular custom. Obviously right. So religious rights related to freedom of religion have come into conflict with many other fundamental rights. Right to equality, for example. Property rights में women को equal share मिलने लगा है. Because of your religious rights or because of right to equality? Obviously, it is because of right to equality. Okay. So whether it is Supreme Court's verdict allowing women to go to Sabrimala or another verdict where they allowed women to go to Haji Ali, many times we have seen that wherever there is conflict between basic fundamental rights and fundamental right of religion, it is generally the fundamental right to equality and life which takes precedence. चलिए, okay. So not just life but also right to equality. इससे आगे बढ़ते हैं. Okay. So it says nothing in this article shall affect the operation of any existing law. अभी काफी लोगों का comment आया, but Sikh community carries dagger. They put on turban, isn't it? Yes. So why is that? If you can just go through this provision and tell me why are Sikh allowed to carry dagger? How is that not, against uniform? Answer is on your screen. As future lawyers, you should have an eye for details. Let's see who can point it out. Well, yes, that's right. Not that difficult. Look at explanation 1. It says the wearing and carrying of kripan shall be deemed to be included in the profession of Sikh religion. So wearing and carrying of kripan was considered essential practice or essential part of Sikhism, and therefore they have been allowed to carry kripan. Okay. But question is not related to kripan, question or argument is related to turban. So shall we allow them to put on turban? A couple of years back in 2018, one Sikh person was debarred from participating in a local cycle race. So there was some cycling marathon taking place and this guy wanted to participate. But organizers rejected his candidature because he was not willing to put on a helmet. For the obvious reason, he was wearing a turban. As he got disqualified, he approached the Delhi High Court. So matter court mein jata hai. Now court asked a counter question. What is the basic requirement of Sikhism? Is it to put on turban or is it to cover your head? Yes, even in Motor Vehicle Act, Sikhs and other people are allowed to put on their traditional headgear rather than a helmet. So there's an exception in Motor Vehicle Act. Why not cycling race? So a counter question was posed that what is more important? Is turban mandatory or covering your head is mandatory? Well, court came to a conclusion that it is not the turban per se, but the dictate is to cover your head, not in a particular, with a particular cloth. ऐसा भी नहीं है कि इसी क्वालिटी का कपड़ा होना चाहिए, इसी लेंथ का होना चाहिए. It is not the height or weight of the turban which is mandatory. It is just the simple concept that you have to cover your head. And therefore, if you have ever seen Milkha Singh never wore turban during his races. Even Sikh community in army, they use helmet for obvious reasons. मरना तो नहीं है ना? ठीक है. So आपका argument that Sikh community is allowed to wear turban is not justified. They have been given an exception only to cover their head, and that too not in a particular style. ऐसा नहीं है कि मुझे यही वाला पटका पहनना है तभी चलेगा, right? So there have been various headgears that Sikh community has been using in different places, but they are allowed to carry a dagger, but dagger is mainly ceremonial, or you can say it is symbolic. ठीक है, चलिए, let's move on. So there are few exceptions to your fundamental right to religion, and those are restriction imposed on grounds of public order, morality and health. So petitioners in this case were relying on an earlier case called Hindu Religious Endowments Madras versus Sri Lakshmindra Tirtha Swamiyar of Sri Shirur Mutt. Slightly difficult for me to pronounce. I hope I got this right. Hindu Religious Endowments Madras versus Sri Lakshmindra Tirtha Swamiyar of Sri Shirur Mutt, 1954. So an old judgment. In this case, it was decided by the Supreme Court that freedom of religion in our constitution is not just about religious belief. It is also about manifestation of religious belief in the form of religious practices. So freedom of religion सिर्फ धर्म मानना नहीं है, धर्म को follow करना भी है. So all your essential practices will also be covered or protected under Article 25. Okay, there's a question, can everyone wear turban or only Sikh? Well, Motor Vehicle Act mentions Sikh community. So helmet की जगह अगर आप कैप वैप पहन के घूमना चाह रहे हैं तो it won't work, right? You will get fined. Don't try it. Anyways, but let's say अगर there is a bridegroom, वो भी तो घोड़े पे बैठ के चल रहा है, हेलमेट नहीं पहनता, सर पे साफा लगाता है, ठीक है. So if you go to villages in interiors, you will find people generally wearing safas or pagadis, by whichever name these headgears are referred or called, patka, domala, dupatta, there are various names. But yes, people do wear their traditional headgears instead of this. Okay. Ovais says, but for Sikh students, turbans were allowed in school without controversy because they were early on quite aware about these things, and जब से हम लोग rule बना रहे हैं तब से Sikh community has been striving to get these rights. But here I would also like to advise you against something. What if this becomes a fundamental right? Don't you think then many conservative families will force it on their kids? 70 years back, 80 years back, ghungat, parda and these things were common in our society. Then various social reformers, various social movements took place and many people contributed. तब जाके ये घूंघट को हमने हटाना शुरू किया. And now just look at it. In a way, we are again trying to establish it as a right. So I, for one, personally, I would say that it is obviously a personal choice, but it shouldn't become so essential or mandatory for you that later on you suffer because of this ground. बहुत सारे एग्जाम्स हैं, बहुत सारे ऐसे प्रोफेशन है जिसमें आप नहीं जा सकते. आई गिव यू एग्जाम्पल, राइट. आर्मी में जाते टाइम आप यूनिफॉर्म पहनेंगे या अपने रिलीजियस यूनिफॉर्म्स के लिए या रिलीजियस ड्रेसेस के लिए एम्फेसाइज करेंगे. इवन सिख सोल्जर्स डू पुट ऑन हेलमेट्स. गोली लगती है सर में तो रिलीजन नहीं देखती है. एनीवे, सो आई स्टैंड विद द गर्ल्स एज वेल एज विद द बॉयज. सबको हक है अपनी मर्जी से पहनने का, और इंडिया में डाइवर्सिटी बहुत ज़्यादा है. But religion should be something that you practice in person, in your personal life. It should be something that you do at your home, that you do in public, but not in public institutes. So अगर आप स्कूल में, आप कॉलेजेस में, जहाँ पे भी यूनिफॉर्म है वहाँ पे अगर आप यूनिफॉर्म फॉलो करेंगे तो that is what should be done. If there is no uniform in your college, school, then you are free to wear whatever you want to wear. चलिए, let's move on. Okay, चलिए. Another news, it's an endless debate. If you want to debate like TV channel, तो हम उसमें चले जाएंगे. I don't want to do that. It's very simple. People should be allowed to wear whatever they want to wear in public places, in their homes. But if at any particular place there's a dress code, then for that particular place, dress code will obviously be more, will have more precedence over other things. Okay. चलिए, so let's wait and watch what the Supreme Court says. If you look at this thing right now, Karnataka High Court has passed an interim order. Interim means temporary order. So meanwhile, till they give their final verdict, till that time, no student will be allowed to wear their religious dresses, and they will only be allowed to use or put on uniforms. Now, some of the petitioners have also challenged this interim order in the Supreme Court. Some people have knocked at the doors of the apex court, saying that this interim order itself is violating their fundamental rights. Okay, चलिए, let's move on. ठीक है, let's see Supreme Court क्या कहता है. Monday को hearing होगा. Monday they will might be they will accept it, might be they will reject it. Next, Posh Act applicable to girl students of a school. Title of the case is Pawan Kumar Nirola versus Union of India. So Calcutta High Court was hearing an appeal against tribunal orders in which it has upheld. Let me just simplify it for you. There was a teacher at Jawahar Navodaya Vidyalaya in Sikkim. Many girls from that school filed a complaint against him regarding sexual harassment. So around 67 female students of that school complained about sexual harassment. And therefore, principal took immediate action. He created a committee, inquiry committee, and after doing that, he also lodged a complaint against that particular teacher, Pawan Kumar Nirola, and this teacher was suspended from the school. He was thrown out. Okay, so let's move on. So in Feb 2020, on the basis of complaints received from the students, Pawan Kumar Nirola was suspended from his job and also arrested under Section 10 of the POCSO Act. What is POCSO? Protection of Children from Sexual Offences Act of 2012. Now there's a twist here. So lower court mein, this guy got convicted, right? He lost his job. I don't think this is visible. I will just remove one set of text. Okay. The school had also constituted inquiry committee immediately after the complaint, और इसको हटा दिया गया. Now, in 2021, accused challenged his suspension on the grounds that as the complaint against him was of a sexual nature, school should have constituted an internal complaints committee ICC first to inquire into the allegations, and because school did not form ICC internal complaints committee, they only formed inquiry committee, suspension was unlawful. Now what is the difference? Let me give you some context here. As per the POXO Act, if somebody lodges a complaint, right, if victim is a minor, if there's a complaint, then arrest can be made, people can be put behind bars, it's a cognizable offense, non-bailable one. But there's another act called POSH. It is Prevention of Sexual Harassment at Workplace. It says whenever a complaint of sexual harassment at workplace is filed, organization needs to create a committee called Internal Complaints Committee in complete confidentiality. Neither the name of the victim or the accused shall be leaked. Nobody should know. Just imagine you are working in some office and there's a complaint against you. Now, if your name is disclosed, then even you will face defamation, right? If victim's name is disclosed, that will go against him or her. So, mostly her. So, in this situation, confidentiality needs to be maintained. Because school is also a workplace, because this guy is a teacher, provisions of prevention of sexual harassment at workplace should have been utilized, should have been used. Accordingly, ICC or Internal Complaints Committee should have been formed, which school didn't do. School ने एक process follow किया, दूसरा नहीं. So, lower court was in the favor of school. Even the tribunal, Central Administrative Tribunal, had upheld this suspension, but matter went to the Kolkata High Court, and now Division Bench of Kolkata High Court has decided that there was a fallacy in the process followed by the school authorities, and therefore his suspension shall be set aside. His pending salary shall also be released. But court also said that this person can be prosecuted and punished under other laws. So court ये नहीं कह रहा है कि उसको जेल में क्यों डाला. कोर्ट सिर्फ इतना कह रहा है कि आपने गलत तरीके से निकाला. You should have formed a committee under POSH Act, not just POXCO. Right? So if you don't follow process, some lawyer will come up with a solution and victim बच सकते हैं. Okay. Verdict. The High Court bench has held that female students at the school are also included among aggrieved women. We are talking about so many different statutes which were enacted to protect women. You can add this one to the list. As defined under Section 2A of the POSH Act. The Act has so far remained largely applicable to workplaces, and this is the first case in a country, this for the very first time, that a High Court has extended its jurisdiction to students in educational institutions. So even that will be utilized. चले, so अब schools, colleges को भी आप POSH Act में use कर सकते हैं. Let me just go through few comments. Okay. Schools going communal in 3, 2, 1. Shaurya, yes, I second you on that. I think that if this controversy continues, हर school में यही होने लगेगा. Okay. Give a glance about Buddhism. We'll talk about Buddhism someday, not today. 60s. Okay. Some of your batchmates, good to know that. Let's move on. Well guys, couple of questions. Let's see how much were you people able to remember. I have set up a new setup here, so now onwards your classes will be more interactive. First question on your screen. Marital rape has an exemption under dash of IPC. Let's see how many of you remember. Quickly answer in the comment section. Jaldi se. Marital rape has an exemption under dash of IPC. So there's an exemption under which provision? Okay, Aranya will go with A, Tanishka Jagtap will go with B, Vardhan will go with A, Seven Sound will go with A, Satej will go with A. Correct answer is option A. This is exception 2 of section 375. Next question on your screen. Marital rape violates article of the Constitution. Which article of the Constitution? Rape is an offense. It violates multiple fundamental rights like your right to live, your right to equality, and also your freedom of expression, right to consent. So correct answer here would be option B, 19(1)(a), freedom of speech and expression. Next question on your screen. The Supreme Court has held that freedom of religion in our constitution is not confined to religious beliefs only, it also extends to religious practices. So this interpretation was given in which landmark case? Options are quite confusing. Madras versus Sri Venkatesha Tirtha Swamiyar of Sri Shirur Mutt, Madras versus Shiva Swamiyar of Sri Shirur Mutt, Madras versus Sri Lakshmindra Tirtha Swamiyar of Sri Shirur Mutt, Madras versus Sri Lakshmi Narayana Tirtha Swamiyar of Sri Shirur Mutt. Charu, if that's your answer, that's incorrect. Arya, that's correct. Satesh, that's correct. Tikshita, that's correct. Vardhan, that's correct. Akshay, that's correct. Correct answer is option C, guys. Madras versus Sri Lakshmindra Tirtha Swamiyar of Sri Shirur Mutt. Chale, last question. The case to criminalize marital rape is filed by Dash Foundation. Which foundation? Name of the lawyer who was arguing this case was Karuna Nandi. So remember this name. I was going through the judgment. Arguments put forth were amazing. So she is definitely going to make a mark. And we might get to discuss a few more cases in upcoming classes. The correct answer for this one is option B. Okay, sorry, I missed one question. What's the full form of POSCO? Sorry, POXO होना चाहिए, POCSO. It's not POSCO, it's POXO. So there's a typo in the question. Okay. Protection of Child from Sexual Offences Act, Protection of Children from Serious Offences, Protection of Children from Sexual Offences Act, Prevention of Children from Sexual Offences Act of 2012. So protection of child or protection of children? It is protection of children. Take a good. A, B, C, D. Okay, correct answer is C, not D. Correct answer is C. So many of you got it right. Okay, ये पुराने questions हैं तो we'll skip. ये हम पिछली बार कर चुके हैं. We'll skip this part. And here we come to the end of this session. I hope you guys got to learn something new. If you guys want me to cover any particular case or controversy, or if you want me to cover any judgment, mention that in the comment section. Once this live stream ends, do provide your feedback. If you like what we are doing, like, share and subscribe. याद रखिए, share करने से knowledge बढ़ती है और साथ में subscribers भी. All the best for your upcoming exams and keep watching, keep studying. Happy learning. Bye guys.